If, however, in the course of discovery, Iger's name comes up on texts or in Slack chats or whatever, or someone testifies that, well, we ran this by Bob.
Gotcha.
So you want the other side to at least ask the question, would they really call? Now let's get to the key witnesses and parties. So this is not a binding list.
This is not a subpoena.
Well, this certainly is not a subpoena because a subpoena has to be served on the person in order to be enforced, and that person has to be within the jurisdiction of the court. But these are the people that Gina's lawyers feel comfortable at this stage of the litigation saying, we're pretty certain we're going to want to talk to these people. I will tell you that the general tendency is to overstate this list for two reasons. One is if you don't even, you want to give the other side notice of your intention to use someone as a witness as early as possible so that they can't claim surprise. Number two is to put the fear of God into them. There might be 3 or 4 people on here that they realistically can't get to testify, or who they really don't want to testify because those people might not be friendly to Gina at all. But Disney doesn't necessarily know that.
Right. Gotcha.
So you want the other side to at least ask the question, would they really call Valiant Renegade? I thought Valiant Renegade was on our side on this.
I'll be there.
You'll be there as an expert, of course. So as long as you have a good faith basis for naming someone, you err on the side of naming them. On the other hand, certain names that are omitted, that especially like Bob Iger, that is obviously a policy choice that was made by counsel.
But it's okay. You brought up a name that I was going to throw as a what if kind of situation, Bob Iger. Again, in my opinion, Bob Iger would have had as much to do with this as Bob Chapek, which is probably to say at the time it might have been a lot or it might have been nothing. Because Bob Iger was still there. He's still the chairman of the board. He was the one that was reported widely, including by Alex Sherman at CNBC, all during that period of 21. He was really kind of running a lot of the studio system still from the board position. Chapek and the studio guys didn't get along very well. So that would be interesting. But again, it's like, what would Iger really say? And if by not having him on this list for the audience sake, if you don't list somebody on here, this doesn't prevent you or preclude you from adding them or subpoenaing them anytime in the future, right?
Correct.
Okay.
In fact, and what by omitting Iger from, so judges are correctly skeptical of people who say, I'm suing Apple because they didn't honor my warranty and I want to depose. Come on, guys.
Oh, Tim Cook.
I want to depose Tim Cook.
Yeah.
You don't get that. You don't get that. If, however, in the course of discovery, Iger's name comes up on emails, on texts or in Slack chats or whatever, or someone testifies that, well, we ran this by Bob, and he was very clear what he wanted us to do, something that gives you a real reason to go in and add him to this list. Now you have established your credibility by not asking for the big shot out of the box, but now you say, hey, look, we didn't think it was going to be necessary, but what do you know? This is someone who can testify.
Gotcha.
Well, and that was going to kind of go towards my question here is like, basically what this is, like you already kind of answered part of it, is this is more or less calling up that they probably have some sort of email and or text trail between the two of them. And if this doesn't necessarily mean Kathleen Kennedy is going to show up in court, right? It'll most likely, if anything, be a video deposition, I'm imagining, right, Ron? Or
no, there's no reason for. Okay, these are people who are witnesses, meaning that they are likely to be required to produce documents.
Okay.
And remember, if they work for Disney, they don't need to be subpoenaed. Disney's a party. It has to produce any employee on notice. Doesn't require a subpoena. She may be remotely deposed or deposed in person. That's a developing kind of situation. I prefer to do depositions in person because it enables me to make use of my commanding physical presence. But it's getting harder and harder to get away with the much more expensive and clunky process of doing in-person depositions.
We saw a lot of those. I was going to say we saw a lot of those during like the Johnny Depp trial. You know, where
I was going to say that's what made me think of it was the videos. Yeah,
right. People were remoting in live into a courtroom, like it wasn't a pre-recorded deposition in a lawyer's office.
That's different.
Yeah.
Right. Okay. So
and that's what I was thinking. I'm sorry, Ron. Yeah, I should have.
Yeah.
Oh, you're talking about
specific.
Yeah. Let's I guess segregate the difference between a deposition in Ron Coleman's office versus somebody sitting in a courtroom or WebExing in or zooming in or something.
Right. My point was, let's not get too excited thinking Kathleen Kennedy herself is going to show up in court.
But it's a distinct possibility.
That's kind of what I was getting at. Yeah.
Tom, it's a distinct possibility that she would. Of all the people on this list, yes, knee pain, I agree with you 100%. Of all the people on this list, she is one of the most likely to have to testify in person. Usually remote witnesses are people who are going to fill in a little piece of the chain, maybe a chain of custody issue, just connecting between D and F, but really going all the way to M. A main witness, someone who's a critical witness, you can, as a party, usually insist that that person, as long as they're not in another country or something.
Right.
And this isn't California, so that's not going to be the case. And California is a different country, but not from California. So
it is a whole other country over there.
Yes,
not a good one like Texas. So yeah,
I do think that if this case gets past summary judgment and there's a trial, some of these famous names will. I mean, now there will not be cameras in the courtroom, ladies and gentlemen. Let's get that clear. This is a federal court. The federal judges don't go for this. You can watch appellate arguments, which is a very different thing. You can see two Ron Coleman Ninth Circuit arguments if you want, if you like California. Not every appellate court has video, but no trials are televised. That's the federal court's policy, and probably will be, I think, for a very long time, if not forever.
Let me ask you, if you don't mind, a couple of questions on two
That's what I'm
things
here
you just
for.
brought up. Okay, so number one, I think I heard you mention, and good to see you, Jay, out there. Just in case you didn't see it, I sent you the link in your DMs. If you can join us, buddy. If not, no big deal, but I just want to make sure you're welcome to hop in. So my first question is, I think you mentioned something about that, if I heard you right, they wouldn't necessarily need to subpoena a bunch of individual names at Lucasfilm. You just said they'd have to make their employees readily available.
No, so, you don't have to subpoena. So there are two things when you want to take a deposition, and the same thing goes for getting someone to testify at trial. Everyone knows what a deposition is, right? A deposition is an out-of-court interview taken in by an adversary, where they basically preview what your testimony would be, but it's not taken the same way. Because, in other words, I might call Gina Carano. I'm not going to depose Gina Carano because she's my client, but I'm going to put her up as a witness at trial. What you do at a deposition is you find out as much as possible about what that witness would say at trial, so that they have to stick to their story, and you can plan appropriately, and you go through documents and you ask them, what did you mean here? What did you say? And that's what a deposition is. It's on the record. These days, in a case like this, certainly it's videotaped, as well as being transcribed by a court reporter. It's taken under oath, and it's admissible evidence. In both the cases of a deposition and a trial, there are two ways to get a witness to testify. One is if it's a third party, you serve that party. Again, if the party is within the jurisdiction of the court, with a subpoena that says, under the authority of the federal circuit, of the the United States District Court for the Central District of California, you are hereby ordered to appear on such and such date, such and such time to give testimony. That usually ends up being negotiated. In contrast, anyone who's an employee and who is a proper witness, and there will be disputes inevitably about who is and who is not a proper witness, all I have to do is give the lawyer for the other side what's called a notice of deposition, which looks a lot like a subpoena, but it doesn't have to be served by a process server or in person. On the contrary, I can't have any contact at all with the individual. I have to go through the lawyer for the company, but they have to produce everything, both documents and witnesses that are under their custody or control.
Got it. And that's kind of mostly part of the discovery process, I guess, in that.
Yeah, that's what it is. Yeah.
Okay. Gotcha. Yeah. Cause there's one name on this list that's glaringly absent to me, and I'll let the audience take a guess at who that might be. And others out there that are part of that Lucasfilm.
Hidalgo.
And others in that inner circle that were there at the time and still there at Lucasfilm. I mean, guys like Dave Filoni aren't named either.
Wait, can I get a retake on that? I can do much better.
Well, I mean, we can all, hypothesize.
Pablo Hidalgo.
We'll find out.
There, I think it has the dramatic essence it needed now.
Make sure you're subscribed to Valiant Renegade and join us every Sunday at 6 p.m. Eastern for the live show.